Wangamati.
Kindly respond. Hatukujui, usisimame tu hatukujui. Sawa sawa? Unasema ndio mimi. Sawa sawa? Report yourself. So
Third accused Edward Barasa wa Kanu.
Ndio mimi.
Number 9, Jimmy Barasa Wekesa.
Ndio mimi.
Number 10, Christopher Makoha. Number 12, Nabwala Construction Limited. Number 15, Welco Builders Limited.
Ndio mimi.
Number 16, Nabweso Builders. Number 18, Nasika Civil Contractors Limited. Number 19, Skyman Freighters Limited.
and 12 to 19 accused persons. Mr. Peter Wanyama.
We are together with him. I think it's just a job. Wangila is
Mr. Edward Wangila.
Yes, that's me.
Ms. Catherine Wangamati. Issue the trial directions which will govern the process.
The reason is...
Slow, Mr. Wanyama.
Yes.
Of course, watch it, man. You know the rule.
Yes.
Slow.
Yeah.
Reason?
Yeah, Your Honor, the reason is only one. We have written to the Ethics and Anti-Corruption Commission, actually 2 correspondence. That is 2 letters. Requesting for the documents to be served to us. And then yesterday, my colleague from the office visited EACC headquarters to follow up on the documentation pursuant to our letter of 3rd September 2025, which we acknowledged. To our letter of 3rd September 2025, which they acknowledged the receipt. The purpose of yesterday's visit was to collect the bundle of documents. The documents which the state intends to use. Already your colleague, now Senior Principal Magistrate Zipporah Mishana, ordered that we be supplied with immediately during the date of the plea taking. Your Honor, the outcome of that visit is that EACC informed us that they are not ready to supply the documents. So, Your Honor, the reason why we are seeking for the adjournment is that we will need the documents so that we have an indication on the caseload. The number of witnesses they intend to call.
May I interject?
Yeah.
Some of the issues worried about.
My request, Your Honor, was that documentation that the EACC is supposed to give us so that we can address you on 1 or 2 issues in the pre-trial directions. That is really the reason why. And
Perhaps you come after what I deliver.
Okay.
Address issues where you think possibly you can. Because delivering without directions does not mean end of the comment.
Okay, that's okay, Your Honor. We can come in after. Yeah.
To your request is that this court directs that issues, if any, be raised upon delivery of the pretrial directions by this court, since clearly some of the issues raised in support of the request for adjournment may perhaps be covered by the pretrial directions. Guidelines 5 and 6, the guidelines for active case management of criminal cases in magistrate courts and the High Court of Kenya, and in the quest of exposing this matter fairly in keeping with Article 50 of the Constitution, without undue delay, in tandem with Article 52E of the Constitution, this court issues the direction set out below. Under Direction 2, this court has provided the mandatory information required by the Constitution to be provided to the accused persons, which I believe all counsel have already shared with their clients. And so I will not read paragraph 2. Under paragraph 3, the estate shall be deemed to have complied with Article 50, 2C and J of the Constitution by doing the following. A, if any, tabulating the full list of prosecution witnesses, briefly indicating the nature of evidence each witness will present and the approximate time each witness is likely to take in examination in chief. B, if any, preparing a bundle of documents, binding them serially, save for the bundle of documents retained by the Director of Public Prosecutions for purposes of production in evidence, and tabulating the list of documents in the bundle, describing each document, paginating all the documents serially, indicating the maker of each, the number of pages of each, crowned with a table of contents, clearly indicating the corresponding page number of each document and the range of page numbers for each document. Where only part of the document is relevant to this matter, highlighting the relevant part of the document. C, the number and volume of documents cannot fit one bundle, the state is at liberty to serialize them in volumes. D, the prosecution is directed to serve the said tabulated list of witnesses and bound documents upon the advocates representing the accused persons before the next mentioned dates. E, upon service and to acknowledge receipt, the said advocates shall sign against service of the said tabulated list of witnesses. bundle documents. F, the prosecution is further directed to share with this court the following. Roman 1, the tabulated list of witnesses, and Roman 2, the tabulated list of documents only. G, this court underlines that all copies of the tabulated list of witnesses and the said bundle of documents held by all parties in this matter should be identical to the originals held by this court. Direction number 4, hearing of this case and interlocutory applications. A, hearing of this case will proceed on a day-to-day basis where so directed. B, on the days appointed for hearing, sessions will begin at 9:00 a.m. pronto, unless expressly advised or varied otherwise by this court. C, any preliminary issue which may hinder or is likely to hinder hearing of the matter or cause an adjournment should be raised in accordance with direction number 5 below. D, any special need, for instance, the need for any special attention to witnesses, intermediaries, interpreters, hearing or a mention virtually, should be raised before the date appointed for hearing or mention. E, any emerging issue which is likely to hinder hearing or mention of the matter as scheduled shall be raised in accordance with direction number 5 below. F, on the day, and this one underline every word, on the day appointed for hearing, no application for adjournment will be entertained, and no adjournment will be permitted, except where exceptional circumstances evidently beyond the control of any party to this matter is demonstrated, as detailed under direction number 5 below. Now, direction number 5 in summary tells you what to do if you wish that the matter is taken out. So the taking out cannot happen on the hearing date. On application lodged on the hearing date. In summary, direction 5 tells you if you want to take out the matter, then an application in that regard, that should be served upon all the parties, should be filed and prosecuted prior to any mention of hearing dates. And that will help all of us on that question of trial certainty. Now, under direction 5, we have 4 kinds of notices. A, the first notice is a notice by this court that it will not be sitting. And of course, all notices, the 4 notices, must be brought to the attention of all parties prior to the date scheduled for mention or hearing. So the first notice you will expect from the courts. It will be fired on all platforms, including your email addresses provided. through your phone numbers and through, of course, the notices, the usual notices issued by the court. As I earlier mentioned, the purpose of all the notices is to mitigate inconveniences and reduce trial uncertainties. The second notice is a notice by the party, and this includes the DPP and the accused persons and the advocates. Except in exceptional circumstances evidently beyond the control of the party, no adjournment by ambush and no application for adjournment is permissible on the hearing date. Instead, the affected party shall lodge a simple application for notice of motion, highlighting the grounds upon which the party seeks to have the matter taken out of the cause list. Quickly, a hearing of that application where all parties shall be invited to attend virtually. And the court, of course, will give appropriate directions on that question, including whether the hearing will proceed or not. The third notice is where an accused intends to withdraw instructions from the advocate. That cannot also happen on the hearing dates, or on the hearing date, sorry. That also requires a mention prior to the hearing date to dispose that issue. And the last notice expected is where an advocate desires to withdraw his or her services of representing the accused. That cannot happen on the hearing date. It must happen before the hearing date. But of course, all in this you must file a notice for determination by the court before the hearing date. I've taken quite a while on that because that is where we have issues, but we are managing. Direction number 6, time management. Generally, each party is expected to utilize time considerately and reasonably. So in this court, I will not expect tautology and long stories. If you have a point to raise, this court is sharp enough to pick your point from the first one. So if you do it in one sentence, we will appreciate. We will not appreciate 1,000 sentences for one sentence. And from time to time, I'm now giving a summary of the several directions under Direction 6. From time to time, where court thinks that it is appropriate, it will fix time for a certain event, for example, for examination in chief or cross-examination. But initially, the court will be very slow to fix time unless it observes over time and finds necessity to do that. Direction number 7 on evidentiary objections. As far as practicable, and this one also should be underlined from end to end. Evidentiary objections shall be deferred and raised upon completion of the examination in chief, but immediately before the contested document is produced as an exhibit. Except, and I underline this one, where the objection is of such a nature which cannot be deferred to that stage. Of course, we have categories of objections which can be deferred. We have those, for example, on the lines of examination which cannot be deferred, which must then be raised immediately. What then must you do in that regard? If you have an objection, record it, keep it. Let the witness complete. Then raise all your objections in one opportunity. Before that, the subject document is produced. And that usually happens upon proposal when the document is about to be produced. This is another area where we need help, which wastes a lot of time in court. B, and this area has not been utilized that way. The court expects that where you have objections or you desire to raise objections, you shall have tested those objections with your counterpart and consider whether there can be a consent under 159(2)(c) of the Constitution. I don't know why parties are not utilizing 159(2)(c) in regard to objections. And I've seen this work in some few cases where you think this one and this one is likely to bring issues. You run it against your counterpart. And sometimes the counterpart will tell you, we may not even produce the document, or we will do this and that. So that I utilize Article 159(2)(c) to have consents on areas where you think there may be objections, which may delay the matter. Direction number 8, which should also be underlined end to end, is on plea bargaining. Without prejudice to the right to be presumed innocent until the contrary is proved, as guaranteed by Article 52 of the Constitution, and pursuant to Article 159(2)(c) of the Constitution, which obligates this court to promote alternative forms of dispute resolution, read in sync with both the Criminal Procedure Code, check sections 137 capital A through 137 capital O of the CPC, read further in sync with the Kenya Integrity Plan 2023-2028, which too obligates this court to promote alternative dispute resolution mechanisms, and read further with the ODPP Plea Bargaining Guidelines 2019. Parties are at liberty to pursue plea bargaining where this is appropriate. Direction number 9 is on lead counsel. In circumstances where the accused person is represented by more than one advocate, all the advocates shall be led by one lead counsel of the accused's choice, who will substantially be in conduct of the matter for and on behalf of that affected accused. And the team of advocates, where necessary, will play a supplementary role. Direction number 10 is on allocation of alternate prosecution counsel. In order to ensure continuity of the matter and mitigate the chances of adjournment or delay on account of unavailability of prosecution counsel, the DPP is encouraged to allocate at least 2 alternate prosecution counsel who will be required to be equally familiar with the matter and ready to proceed at all times. Direction number 11, on the obligation of the accused and their counsel to respect the sub judice rule. This is self-explanatory. I will not read the complete direction. Direction number 12 is attempting to or engaging in acts which may unlawfully compromise the integrity of the process. This code does not entertain attempts or acts which may unlawfully compromise the integrity of the process. Of course, that is also self-explanatory. And direction number 13 is on variation of these directions. These directions may be varied by this court, either sua sponte or upon motion of any party, supported by court in principles. Ladies and gentlemen, these are the ground rules which will guide the process. And at this point, I will invite parties to raise any issues, including now Mr. Peter Wanyama, if there are any issues which have come
to fully comply with those orders. Important. Oh, sorry. Yes. 1 to 8, 12 to 19, to know who will be the lead counsel. And that is the counsel we intend to supply prosecution bundle. Equally important to know who the lead counsel is, because I note that there are several counsel representing accused 9 to 11. 9 to 11. So that again, this is the counsel we intend to supply the evidentiary material bundle to, and again, who will sign the inventory that will be filed in court. Further, Your Honor, we intend to supply the evidentiary materials within a period of 30 days. I would like also to know from the lead counsel for the accused persons whether we can serve them in hard copy or soft copy. That is important so that from here we know how then to prepare the bundle. If it is hard copy, we will then proceed immediately and comply with your order requiring us to serialize those documents. That will be all on our part.
Taking to comply with the entire contour of the direction we will issue.
Oh, sorry, I forgot something. Share. These are informal copies. If you require, you are taking to the directions. Continue, Mr. Wanyama.
Yeah, thank you, Your Honor, for the copy. I'm just making the statement that we intend to comply fully with these directions. My Lord, Your Honor, just to point out one or two issues. Your Honor, the nature of documentation that EACC serves accused persons is often quite voluminous. Your Honor, that may have an impact. Usually it has an impact, and the former Chief Justice Maraga once raised this issue. It has an impact then on the trial itself, especially on the question of time.
The speed of complexity.
Yes. The voluminous nature of documentations will definitely have an impact on the time. So I took your note, I took your remarks that the issue of time, controlling the time that the defense needs in cross-examination, that will be affected then with the level of documentation. But I took your note regarding the flexibility of that trial direction. I am saying that because of Article 50, paragraph 2 of the Constitution, paragraph 2C, which talks about the rights of accused persons, and the question there is adequate time. Secondly, but on that question we will cross the bridge, I believe, when we reach there. It is not, from the pretrial directions, he talked about some flexibility, where there is need to control time. But Your Honor, I will be urging that you don't control time. I am seeing the storm, Your Honor. Already from the time that the state intends to take to supply documents, 30 days, that could be quite a number of documentation. Your Honor, secondly, this we can agree with the DPP, whereas there are 19 accused persons in the charge sheet, and noting the obligation of the state in Article 50, which talks about every accused person has the right to be supplied with documentation. Every accused person. In this case, ordinarily, it is all the 18 accused persons to be supplied with all these 30, all this heavy documentation within 30 days. Against that background, we can agree with the defense, with the state, that they supply us with only 7 copies. 7 copies of the bundle, and Your Honor, that will cover the clients that we represent. So 7 copies, and Your Honor, we have seen an excuse, a slight excuse, where they say they want to supply us with a soft copy. Your Honor, we insist on hard copies. That notion that soft copies can be supplied, they actually contravene the right to fair trial in Article 50, which talks about being supplied with documents. And then, in the context of time and facilities to prepare. And secondly, it's also important to emphasize that in your own directions, it's about a bound copy. So a bound copy necessarily indicates that it ought to be a physical copy. So let the state not create those excuses. Your Honor, administratively, I will coordinate with the EACC on the picking of the physical copies of the documents and sign for them on behalf of my colleagues. Your Honor, 30 days is really on the higher side. Nonetheless, Your Honor, we are the ones being prosecuted. So we will sit back and wait for the 30 days to be given these documents. But Your Honor, on that question, we just wanted to get the exact date so they don't create, we don't go there and they say we don't have documents. So Your Honor, we need some definitive, a date to be set where we'll go and collect these documents. That at either the DPP or EACC. You want to think that will be all, because I think there is an order here on direction 13 that your directions are not cast in stone. If there are any emerging issues, we will move the court in accordance with the substantive directions. And Your Honor, we also understand the subjudice rule, and also direction number 12. And Your Honor, direction number 7, we also note, because I handled once a prosecution, an anti-corruption case, where it is actually necessary to raise an evidential objection before waiting for the production. Yeah, but Your Honor, I understand your sentiment that is not cast in stone. You will be looking at each case on its own merit. Your Honor, usually the reason here is that it can be prejudicial to the accused person. So we just request that EACC and DPP, they put their house in order so that we don't raise evidential objections, especially before the witness finishes the examination in chief. The other issues that I wanted to say are not related to pre-trial, but that is all in respect to pre-trial. Just to highlight to court that we have another application with notice of motion which we have filed, and we wanted to request that you give indications whether you will hear that notice of motion application together with another application for substitution of securities. That is all we want.
Just first of all, speaking, we know setting the big.
Highly project your
Self-explanatory and fair.
what is true?
The bundles for the accused, the counsel representing accused 9 to 11.
2 for
2 for them, 7 for the first batch.
lead counsel. You only see it on 31st October 2025 at exactly 9 to confirm compliance and for further directions of the court, including fixing hearing dates. Now to the application, Mr. Wanyama.
I believe that the next application should relate to Mr. Wanyama. I'll be free that I will discharge because I have another hearing.
Or you're not party to that application?
Yes.
Very well. Discharged?
Yes, Your Honor, I have served the